Okay, everyone, welcome to this. Just make sure everybody. Oh, yeah, there we go. Okay. Welcome to this month's HR Best Practices webinar series from Thompson Co. My name's Kevin Mosher. For the last 5.5 years or so, I've been doing these webinars, and other people have joined in. And next month, we'll have a guest speaker, webinar presenter, so that'll be exciting. But this month, we're going to, for the October 2017 version, we are going to look at complying with workplace immigration laws. So a lot has changed over the years, as you can well imagine. A lot more will change in the future. I think the Trump administration is just getting its feet under itself on immigration. Not, there hasn't been a lot of talk around the time of after the election, around the time of the inauguration, with the travel ban and that sort of thing. But as far as workplace compliance goes, there's not been a lot done, at least that's readily viewable or measurable, that I've seen or heard, or that's even really been implied. Most of everything seems to be focused on building a wall and that sort of, reality or metaphor or whatever your perspective is. And we haven't seen a lot done at the workplace level. So we're gonna get into, where we stand currently and best practices that employers, should be looking at going forward. And it's just, looking at immigration compliance, it's just a good time to do it, maybe before a lot more enforcement comes down the road, if it ever does with this administration. So we'll jump into that. For those of you who are with Illinois or Minnesota CLEs, we'll be sending certificates out on that. HRCI, SHRM credits, after the presentation, we'll also send out those to you. And on the right side, if you're newer to the webinar series, welcome. And thank you for joining us. And on the right side, you'll see questions, and you're welcome to write your questions in the box, and I'll try to do that. If you raise hands, it doesn't really do us any good, since this is just a one-way presentation. We used to do the audio, tried the audio, and used to do this on the phone, and that was great, but it was just too difficult trying to take over the phone questions and everything. So we do this more one way. So you're welcome to write in your questions on the right side, and I think I should have some time today. So hopefully time will allow, and I'll be able to address those as we go. We do have a lot to cover today. So, but I think we can. We're not going to dive too deeply into any of these. I mean, the Form I-9 alone can be a 3 or 4 hour presentation. So we're going to talk about some tips and an overview of the Form I-9, for example. For those of you that do want more I-9 training, and if you're on the HR Hotline program, you're welcome to go on the website, and you can watch previous presentations on the Form I-9 itself, including the revised form that's been revised in the last year. Okay, so here are the general topics that we're going to cover. And again, like I say, immigration it's a hot button topic these days. A lot of talk about illegals, not a lot actually being done about it, but a lot of talk, and maybe more being done, I would say, at the U.S. Embassy level when they're reviewing people who are trying to come in on green cards and H-1Bs, and obviously the DACA issue is coming, and we've talked about that. We talked about that last month, in the last month's presentation. So there's been a lot more talk than there's actually been action on the worksite enforcement side of things, but I think it's really, really good to get up to speed on all this stuff. So what are, the problems that employers have historically had have not really been fixed by the government. Shocking, I know, but really what the problem is that we have this societal expectation that employers not employ illegal or undocumented, I don't care how you want to put it, illegal, undocumented, doesn't matter to me, but illegal, undocumented workers. And the reality is, for a lot of employers, depending on if you're in the agriculture industry, or if you're in light manufacturing, if you're in an urban area, or if you're in a rural area and you're having a really hard time recruiting, the reality is that you're going to have employees, whether you know it or not, that are going to be without proper documentation. Now they might have good documents that are faked that you don't know about, and that's okay. And we'll talk about how knowledge is the key from an employer side of things. It's only if you have knowledge that the person is undocumented, that they're illegal to work in the United States, that you then actually have then you have liability or culpability as an employer. If you don't know, then you're absolved of fines. But society expects more of businesses, and so we've got the law, and the law talks about knowledge and how when you hire somebody, you have to verify. And we'll talk about the I-9s. That's how you fill it out, but how you have to verify that the person is authorized to work in the United States. So that's the law, right? But the reality is that the government doesn't give us a lot of. We've got EVerify, and we'll talk about that. But there's not a lot of resources that the government provides to employers to really know if the person sitting before them that they've just hired is legal or illegal to work in the United States. I mean, again, we can do the I-9, but you can go down in any major city in the United States and buy counterfeit documents that look pretty legitimate to most employers. And then the law says that, again, you have to knowingly not hire illegal workers. And then also, with regard to those documents, you don't have to be an expert. So if somebody shows you a really good fake, it's okay. Like, there is no legal liability. There's no liability for you in that situation, because you have just used your reasonable person, and you don't have to be an expert in documents. And if the document was reasonable looking, then good enough. The law doesn't require that you be any better than just a reasonable person, and the law doesn't require that you do anything else. You don't even have to be an EVerify, for example. So you just have to look at the document and then record it. And so that's the law. The government expects you to do more. So even though the law says one thing, the government, when they go through these phases, and they're not in one right now, but when they go through these phases of prioritizing workplace raids and workplace enforcement against employers, then in those situations, the government, it's like they expect employers to be better than what they are, and the employers are the ones that really get damaged in this situation. I mean, obviously, families of people that are deported, not great and everything, but the employers, they end up losing out, because an employee who presented a fake document and is now being carted off by ICE, they just lost a good worker, and they might lose an entire shift, and then the next day, like, none of the shifts show up because people are scared. So the government starts enforcing, but they don't really give us the rules, and the law itself doesn't put a lot of liability on employers who are just trying to be diligent. But then society and the media, and maybe the executive branch, expect a whole lot more from employers. They expect them to go above and beyond, and to really investigate, and to not hire illegal workers at all, when the reality is that the law also says that you can't be overly diligent, because that's potentially discriminatory. So damned if you do, damned if you don't. But this is the conundrum that employers have for years found themselves within, and I really think that it's just going to get worse, especially with this newfound nationalism and fervor over illegal workers and people in the United States. So I don't think that employers are finding it, even though government's not enforcing a lot of raids on an employer fines right now. They're doing more raids to get the illegal immigrants themselves, rather than going after the employers on employer compliance. So I don't think, until the government gives us more resources or changes the whole Form I-9 and everything, I don't think employers are going to be benefited by this. And I do think that the media and society seems to be increasingly xenophobic and going after employers and getting bad press and maybe bad business. So as a result of hiring just workers who end up being undocumented and illegal. So, okay. Immigration 101. All right, so we've talked about a bunch of general concepts right there that are going to guide us for the next 50 or so minutes. So, obvious rule of the day. You probably all know this as employers working for employers and companies and nonprofits, that sort of thing. But a person has to be authorized to work in the United States to actually work in the United States, right? No brainer. And the way we do that is we as employers, we have documents that are recognized by the government that empower us to work. So it might be a U.S. passport, not a foreign passport, a U.S. passport. It might be the combination of a Social Security card, which is a work authority document, and a driver's license. It might be an employment authorization card. It might be a visa. If you've sponsored somebody to come over on a visa, or if they've gotten a visa, it might be a green card. These are all work authority and identification documents that the government has identified as being the types of documents that that employers can look at in order to determine, meet their minimum obligation of confirming to the best that they can that the person is authorized to work in the United States. And that's it. So you just have to hire somebody authorized to work in the United States. But if you're hiring somebody from, Switzerland, and they have a Swiss passport and they don't have a visa and they don't have a driver's license and a social security card, well, you're hiring somebody who's illegal, right? Or at least illegal. They might be here legally in the United States. They might be here on a tourist visa or something, but it doesn't mean that they can wait tables for you. They still need to be authorized to work in the United States. They're going to need to get a visa or a green card in that situation. But you as an employer have the obligation. It's your burden to prove to the government that you have gone through the diligent steps, that you've hired somebody that's authorized to work in the United States. This law has been around, I think off the top of my head, it's like November 6th, 1986 that it went into effect. And that's basically the law that bore out that gave birth to the Form I-9 requirement, as well as other, immigration laws. So yes, we're celebrating like 30 years of the Form I-9, which is pretty exciting. So what is, here are some tips, here are some key categories that that law requires of employers. So it does, like I said, requires that employers make sure that the newly hired employees, have work authority, that they are authorized to work in the United States. It gave the employers all the requirement that they do the Form I-9s. If you have current employees that have been hired since November 6th, 1986, and they're currently working for you, and if you don't have an I-9 on file, you're in violation of the law. So these are the sorts of things that we stir up in audits. But basically, you have to have an I-9 on file for any current employee that has been hired since November 6, 1986. If they've recently terminated, you're going to have an I-9 on file for them for at least a year. So we have to have I-9s on file for a minimum of 3 years. But if somebody works at least 2 years for you, you have to have the I-9 on file for at least 1 year after their last day of work for you. So, and then you can get rid of it. But you need to keep these I-9s on file for all current employees, and then also former employees for at least a year. It also said that you can't discriminate against people. A little known, little discussed element to immigration laws, but we often talk about race discrimination under Title VII, and then disability discrimination under the Americans with Disabilities Act as amended, and equal pay. And so these are other, much more common forms of discrimination. But actually the immigration, the INA, it created, it prohibits discrimination against people because of their citizenship and national origin as well. So you could actually be sued for citizenship discrimination. It's different. It doesn't go through the EOC. It goes through the Office of the Special Counsel through the Department of Justice. But it happens. I've dealt with it for employers for sure. And you could, if you refuse to hire somebody because of their citizenship status, because they're here on a green card, for example, and you don't want to hire people on green cards because of your bias or whatever. Well, you could, you're looking right down the barrel of a citizenship discrimination lawsuit and charge from the government. Okay, so what is exactly work authority? Work authority is the lawful ability to work in the United States. Again, it doesn't, and that's why it's more accurate when we talk about people who are undocumented or illegal. It's more accurate to say undocumented. Because of my Switzerland example, for example, I mean, people from who are like on ESTA, who are coming over to travel in the United States from Europe or other countries throughout the world, they can come to the United States for up to 90 days and travel around the United States. So they're legal. They're totally legal to be in the United States, but they're undocumented. So anyway, I think it's a little bit more accurate to say undocumented. So again, work authority, it's the lawful ability to work in the United States. The person has to have documents, legitimate work authority documents, to prove to the employer that they can work in the United States. If you if you're hiring somebody as an independent contractor, kind of a loophole, you can kind of get around that. They have to be a legitimate independent contractor, and that's a whole nother ball of wax. And again, those of you on the HR Hotline program are welcome to watch the previous video, all the videos on independent contractors and determining that. But employment is generally to suffer to permit to work. If you are a legitimate independent contractor, you should not be looking at somebody's I-9 documents. You should not be concerning yourself with their work authority, because that actually potentially takes on more liability and knowledge than you need. And so we not recommended that if the person's legitimate independent contractor, it's not recommended that you actually look at their work authority documents. But how do you get work authority? You could be a U.S. citizen. Everybody born in the United States is, has the ability to work in the United States. You still need to prove it. A person could be a U.S. citizen, but if they don't have a passport and they don't have a driver's license or a social security card and they can't do the I-9, well, by day 3, they shouldn't be working for you. I'm born and raised in the United States, but if I can't prove to my employer that upon hiring that I have work authority in the United States, my employer should not be letting me work past 3 days. Past 3 days, that employer is taking on a whole lot of risk to themselves. Not me so much, because it's not like the United States is going to deport me or anything. I'm a U.S. citizen, but the employer's responsibility is to take a look at the documents, and so that's the liability that the employer takes on. So we could get work authority through citizenship, there's green card. That's a long time process, a bunch of different ways. If you're thinking about sponsoring a current employee for a green card, let me know. We can talk about it, but that's definitely something employers can help non-U.S. citizens to get. Employers can also sponsor employees, people for visas. And people can there are certain visas that people can get on their own, but for the most part, when we're talking about work visas, we're talking about employers being involved at some level. And again, feel free to give me a call and I can run you through anything specific with regard to those visa and green card issues. If you do hire somebody without work authority, so what's going to happen? Immediately go to jail, right? No. So you're not immediately going to go to jail. Jail is you could go to jail. Jail generally, as you can imagine, is reserved for those people who are in the biz of trafficking and making money off of trafficking, illegal and underage workers and sex trade and that sort of thing. So those types of people, criminal masterminds, in concert, those types of people, that's generally what we're looking at for criminal penalties. Doesn't mean the federal government couldn't threaten you with criminal penalties, but really in order to be criminally culpable here, they've got to prove, you have to really be going out of your way. Nobody on this call, hopefully nobody on this call is engaged in trafficking illegal workers and that sort of thing. If you just accidentally hire somebody, or honestly, if you just purposefully hire 1 or 2 people, you're probably not looking at criminal penalties. No promises, obviously, but for the most part, criminal penalties are reserved for some pretty bad actors that are going out of their way to violate federal law. Monetary fines, however, absolutely. If you are hiring somebody without work authority and you know about it, and the government proves that you knew about it, or they've come to the conclusion, they certainly will issue fines. And I've got a framework showing the fines in a minute, but But absolutely, you're looking at fines, and you're looking at a fine for every, for every violation, including fines for I-9 for paperwork violations. So paperwork violations, just failing to fill out the I-9 correctly, can get you some pretty hefty fines. It can add up pretty quickly depending on the size of your business. But then the more serious fines are if the government determines that you knowingly hired an employee. To work for you illegally. But then, again, growing with the temper of the United States right now and media, it seems, public humiliation and business loss. You can see, especially in this viral Twitter, crazy world where information and misinformation spreads very, very quickly to people. I mean, you can imagine how quickly bad press could get around, could go viral on even, your company in, say, northern Minnesota or something. This sort of thing happens. I know there are a million different, or I shouldn't say a million, but there are a lot of different situations where they've gone viral, and before you know it, like, people are out of work, businesses are closing down, they're losing all their customers. It's you can go from a pretty viable business pretty quickly to a pretty bad situation. And one of the ways that I think you can go into a pretty bad situation that goes viral, that loses customers, that loses business, and humiliates, bad publicity, is by hiring illegal workers and being caught in doing it. So I think there are increasingly severe societal costs to hiring illegal workers. I'm not saying that's good or bad, but I think it's a reality that most businesses should really factor when they're considering their risk and their policies. And so I would recommend, and we'll lay out here and we'll talk about I-9 audits and being as diligent as possible. So I would recommend, training and really paying attention to immigration laws and compliance in the in your practice. So what can't employers do under federal law? Well, you can't knowingly hire unauthorized workers. And again, the key there is knowing. You can't knowingly hire unauthorized workers. Doesn't mean that the media is not going to, take you to bat for hiring unauthorized workers. You might still get some really bad press, and it might go on Twitter and it might go viral, but you're not going to get fined by the government. You're not going to get prosecuted unless they can show that you knowingly hired unauthorized workers. But again, when in the Twitter age, that knowingly thing is probably going to be lost, and you just some being extra diligent is recommended. Failure to complete the form I-9, have to have an I-9 on file for all current employees, and then at least all employees fired in the last year or not working there in the last year. Can't discriminate based on citizenship, national origin, or immigration status. That's not to say that you have to hire everybody who's here on a work visa. People who are here on most work visas, those are not what this webinar is about, but they are here on non-immigrant status. They're non-immigrants. So people who are not non-immigrants, like H-1Bs, F visas, those are students like STEM, they're going through like a STEM program or something like that, or H-1Bs, or L visas for international executives or people with business knowledge. Those people are, they're non-immigrants, so you don't, by saying you don't want to sponsor their visa, you're not looking at discrimination. For the most part, we're looking at citizenship discrimination based on. But for people who are here on green cards, if you have a policy of not hiring people on green cards, that could be a potential problem. People who are here in asylee status, if you don't want to hire people from Honduras or Ecuador for whatever reason, but they have legitimate work authority, that's a potential problem. So could violate the INA from 1986. You also can't, and this is where more employers will get into trouble. You cannot request specific documents on the Form I-9, and you can't ask for more documents than is actually required by the I-9. So the best practice when doing the I-9 is just to give the person the I-9, and they can see on the page. Hang on, I think I actually have a copy of the I-9. Let me. I think it's showing. Yes, I think everybody can see this. Okay, so here's the I-9, right? So here's the third page, and so yeah, third page. And so recommended is that you just show the employees this, this third page here, and just let them choose, right? So let them choose either a list A document or a combination of B and C documents, rather than what a lot of employers do. And I'm not saying it's bad, but it's not recommended. You shouldn't do it. It's probably document abuse and illegal. But it is, a lot of employers will just say, well, bring your social security card and driver's license, and that's not the way to do it. The way to do it is just to show them this third page, email it to them, give them a copy, whatever, present it in front of them, and then ask them, and then you have to get these documents by the end of the third day from them and record it on the I-9. But anyway, showing them this document's the best practice. Okay, I think, oops. There we go. Yeah, okay, yes. So that's the I-9 doing that. The other thing that you can't do, it's kind of a no-brainer for most employers, but hey, there are hundreds of people that go to jail every year for illegally hiring and recruiting for a fee, undocumented or illegal workers, bringing them over the border, that sort of thing. So anyway, it is prohibited, and there it is. Hire, recruit, or refer for a fee workers known to be unauthorized to work in the United States. Don't do that. Penalties. Here are the penalties. You could do up to 6 months in prison if you are convicted on this. More to the point, really more what you would have to worry about is first offenses. If you hire an undocumented worker and the government shows that you knowingly did it, you are looking at a fine per worker of anywhere from $548 to $4,384. That just recently went up a couple weeks ago. And so that's your first offense. And so if you've got 20 people in your first offense, I mean, hopefully you don't, but if you do, you've got 20 people in your first offense, let's just say they could fine you $2,000 per employee. And there are escalators within this, and if anybody is really curious to see what they are, I can find it and send it to you. But there are escalators that determine if it's $548 or $4,384. But that's the top end limit, the $4,000. Now, if it's a second offense, even if it's just like one person, but this is the second time that the government's had to come in and find that you knowingly hired somebody illegally, a minimum second offense is the maximum of the first offense, and then it goes all the way up to $10,957. I think you get the point from there. If you're looking at an I-9 paperwork document violation, you can see $220 for per offense. And if you are a company of 1,000 employees, that's a whole lot of I-9s. Also, the I-9s for previous employees that you still have on file. So you can imagine that a fine of, let's just call it $1,000 per I-9 paperwork violation, if you've been in pretty bad compliance and haven't really paid attention to the I-9s and haven't been auditing and haven't really done a good job completing the form, you can see where $1,000, right in the middle of that, I-9 paperwork violation, you can see where $1,000, and you could, company of 1,000 employees could easily, have 100 or 200 I-9 paperwork violations. That would not be uncommon at all. So, right there is $100,000 to $200,000 fine. So it pays to follow the I-9 protocol and to do training and to audit and to make sure that your I-9s are in good shape, because ICE doesn't mess around with those fines, and they come after you pretty hard. And like I say, it could be over $2,000 for just your for just a paperwork violation, which is kind of ridiculous, right? Probably not in your budget. So that's probably not something you have in your budget. We always like to budget for about $200,000 in ICE fines per year, right? Said like no HR person ever. Okay, so what to look for on the so things to look for in the workplace, right? So among your employees, these are just kind of some tips. There might be some other things. Again, I'm not saying this is an exhaustive list whatsoever, but from my experience and in talking to a lot of employers over the years, these are just kind of the tips, the keys that might tip you off to a current employee or a prospective employee being undocumented in the United States. So again, just run through this, but you can add to this list if you've got some other situations. Employee changes their name without a life event. I mean, I'm not saying people change their name, they get married, they change their name, that sort of thing. But if somebody changes their name, they come in and they say, hey, my name was Kevin. I've been Kevin for the last 5 years that I've been working for you, but now my name is Peter. Well, okay, why? Why is my name Peter? Why is it changing? This is a tip off, right? That well, it's probably more of a tip off that I was illegal and then I just somehow became legal. But who knows? You never know. Maybe the person whose identity I stole figured it out, and now I have to go steal a new identity, and so my identity of Kevin is no longer good. So I need to now move the identity to Peter. So. But again, this is a trigger that might trigger you to ask some questions about what's going on with this employee. You might receive some sort of notice from Social Security. Back in the day, years ago now, it used to be the old Social Security no-match letters would go out. So anyway, if you hear from Social Security, notice from ICE, obviously that's a big one. If ICE comes in and does an audit, they're gonna take some time and they'll send you a letter notifying you that the documents, that the records don't match. That's obviously a huge trigger, and if the person's not able to fix it, then ICE could fine you, and you could be looking at some knowingly hiring and continuing to employ somebody. EVerify, if it comes up as a tentative non-confirmation, that's obviously a pretty good trigger. Communication from an individual, somebody saying they overheard so and so talking about I don't know, sneaking over the border or whatever, but workplace communication. Sometimes people just admit to things. I'm not saying everybody's super smart here. People sometimes will come in and they'll think they've got some sort of confidentiality or whatever with HR, and they might just disclose that, hey, they're they've got to go overseas to get some new documents or whatever because they imply that they're illegal. You might get a communication from the Federal Trade Commission or another government agency that's investigating identity theft. Local police might also call. Local police might call because maybe somebody admits to being illegal to them, and the local police are being proactive and they give you a call, they give you a heads up and tell you that the person's like locked up or maybe it was picked up. That could happen too. Some banks, because of Sarbanes-Oxley, might be checking records, and they might notify you after a SOX check. They might notify you that the records are not matching. Social security numbers and stuff aren't matching, so that could happen as well. There could be a different name with family and friends. I recall a situation where the person went by a different name at church than she did at work. And that could happen, right? Lie to your employer, but not to God, I guess. And so that might be. You might just know in the community, like, hey, they're known as Kevin, but here at work, I'm called Peter. Like, why is that? They might refuse to travel abroad. People who don't, who are illegal in the United States, try not to leave the country unless they try to come over, sneak over across the border, which is always dangerous, and nobody really likes to do that, right? So they might refuse to travel abroad for whatever reason. The documents look bad, even to your reasonable person. We talked about the reasonable person standard before. Even to your reasonable eye, these documents look bad. Well, you can definitely ask about them, especially at intake of a new employee. You can ask of them, hey, this looks fake. This number doesn't jive with the rest of the form. This picture looks terrible. What's going on? You can definitely question these documents. The information's bad. You can ask the individual to explain the discrepancy on a document. And at the I-9, this is all section 2 of the I-9, right? You can ask the employee to give you something else. Like, you don't have, if you think a document is not legitimate, it's sketchy, you can definitely ask the employee to give you another document. A lot of times there are, I mean, I don't want to say a lot of times, but sometimes there are raids. And, so if an employer in the same office complex or nearby is raided, it's very common, whether they're legal to authorized to work or not, it's still common for a lot of people in this country to just not come to work the next day because they don't want your business maybe to be raided. They, if the government's in the area, ICE especially, they don't want to be around. And that's why when ICE swoops in, like, they, come in with choppers and local police, and it's a big deal. And they're, taking people under arrest a lot of times and stuff. It's a big deal because they know people are going to flee. And so it's just kind of it scares everybody. It scares everybody in communities. And so, suddenly might have nothing to do with you, but a bunch of employees, like an entire shift, just might not show up the next day. And so that's a risk that you run, but it's something to look for, because if you hear about raids in your area, depending on the demographics of your workplace, you might want to start making some preparations. Refusal to engage with government officials, and I'm not saying that's like a major trigger or anything like that, but you never know. Based on the circumstances, it could be bad. Dealing with undocumented workers. Okay, so if you're suspicious of the documents, if you've got some suspicions, like maybe at intake when you were hiring the person, they were just a little sketchy with the details and talking about, their identity and stuff like that when you were doing the Form I-9. And maybe you were just a little uncomfortable with it, but you didn't actually think it was enough to tell the person that, to refuse the document. Well, you could still document that. And just kind of put it aside. And I'm not saying put in the personnel file or anything like that, but you could definitely document that there's some suspicions there, because then a year or two later, some other situations might come up. Like the person gets a work comp injury, but they refuse to, pursue they refuse to go to the hospital. They refuse to get involved with it, which sounds great and all, but probably not necessarily what you want when people are injured in the workplace. But people who are illegal in the United States, they for the most part just try to avoid the government and avoid hospitals sometimes, and other situations where there could be reporting. Not all. Some don't care, for sure, and might even bring lawsuits. But for the most part, they try to stay under the radar, right? So, but if you have suspicions, however the suspicions come, whether it's like somebody calling in or a police officer or something from ICE, then just document it. The next thing I would do is look at the person's I-9. Take a look, see what's going on. If you get some random call from somebody saying that so and so has stolen their identification, and they want you to fire them, you don't have to fire them, but it is suspicious, and I'd look at the I-9. I would then confront the employee. So this is kind of a to-do list, right? If you have suspicions with undocumented workers, I'd confront the employee about it. Ask about the who, what, where, when, and whys. Try to figure out the story. A lot of employees will admit to it. A lot of them won't. And if they don't give them, but you're still suspicious, then I'd give them some time. Reasonably, the standard is a reasonable amount of time. There's no minimum. There's no maximum. I don't think I would let it go past 30 days is generally a good time frame. I think beyond 30 or 45 days, you're getting pretty, getting into, dragging it out a little bit too long. It used to be back in the day, it was 90, but that's not really the standard anymore. I'd let somebody try to correct a problem and address suspicions. I don't think I'd give them much more than 30 days. Document all this, and then if you do tell the employee to go and bring you new documents or somehow alleviate the suspicion that you've got, then I would do a letter to the employee confirming it, and confirming that they need to bring this documentation, whatever the documentation is, back to you. They need to bring it back to you by, such and such date. And I'd put that date certain, and then I'd say, well, I'm planning to, on that date, let's just call it December 1st, 2017, I'm going to review your documents with you. And if you don't have it, then we'll proceed with terminating your employment. And then just actually, if they actually do. So then that date comes, let's call it December 1st. That date comes, you're going to review their documents. That's great. Maybe they brought them to you beforehand, but oftentimes December 1st comes, they haven't done anything, or they just don't show up that day, and then you fire them, or should fire them since you threatened to do so. Okay, I've been meaning for many years to use Destro as my scenario person. So anyway, this is Destro, and he's not happy, but he's a good employee. So after a hard day of work, you take Destro out for a pint, and he asks if he can confide in you. You agree? Okay, no problem. Destro, you seem trustworthy and everything. He tells you that his name's not actually Destro, but it's Larry Lebowski, and he's a former lumberjack and Canadian citizen who overstayed his TN visa. Astounded, you ask him for proof, and he pulls off his mask and then starts singing Canadian lumberjack songs. So you're convinced, right? Because who else but Canadian lumberjacks would know Canadian lumberjack songs? Okay, so and you can actually get a TN visa. The strange thing is you can get a TN visa for being a lumberjack in the United States, and that's true. So so what are you going to do here? You've got Destro. Destro's been working with you. He's now confided with you. You're an HR person. You're an agent of the company. You now have knowledge that he's not documented to work in the United States. And so what are you going to do with Destro or Larry Lebowski here? Well, if you let him work, if you let him continue to work, that is knowledge. There's your knowledge. He is admitted to you that he can't work in the United States, at least not doing what you do, which is not being a lumberjack. And so if you let him continue to work, it doesn't matter that he's a good employee, doesn't matter that he's from Canada. If you let him continue to work, you're going to be taking on liability for yourself. You could be fined. I wouldn't spend too much time worrying about going to jail, but you never know. It's always possible, I guess. Probably not something you want to chance. And so, yeah, if you're going to continue to let him work, you're going to take on liability for you and the company, and in violation of federal law. Can you help him? So probably not. After somebody, I don't have a slide on this, but after somebody has been in the United States and has worked in the United States illegally, they're going to be barred from re-entry. They're going to have to leave the United States to get. So in order to help him, you're going to have to get him a new visa, right? Or sponsor him for a green card. That's going to take a long time. But you're going to have to get a visa for him. Well, the problem is that in order to get the visa, Destro is going to have to leave the country, or Larry Lebowski here. Larry's going to have to leave the country, go back to Canada, and then he's going to have to go to U.S. Embassy, and he's going to have to apply for a visa to get back in. And then they're going to look at the records, and they're going to ask him, like, did you work in the United States? And assuming he is honest and says yes, they're then going to say, well, how long? And he'll say years. And then they will say, yeah, no problem. We'll be happy to approve this visa in 10 years when you can go back into the United States. So that's the problem. That's why people come over to the United States illegally. And they walk across the Minnesota border or whatever in the boundary waters, or I've heard people cross at the Texas border as well. I think I heard that somewhere. And so that's what you're looking at. And so that's why, yeah, you could help him, theoretically, but probably not. You probably can't help him much in this situation. And so you have to decide, you're going to just part ways with Larry, or are you going to take on the risk of continuing to let him work in the United States? Because really there's not much, under current immigration rules, there's really not much in the way of a path for him. Immigration compliance strategies. Here is a list of ideas for you that I recommend if you want to, put together a better or a solid immigration compliance program. The one key here that I think is really important is centralizing your I-9 process, not having managers at far off facilities that really don't have I-9 training, not having them be part of the I-9 process, or if they are, being monitored heavily with it. Enrolling in EVerify. EVerify is a nice program, I think, that's become much more efficient over the years. It's going to weed out a lot of people. If you want to hire undocumented workers under a wink wink nod nod type of scenario, don't enroll in EVerify, because the good news is it's getting better. The bad news is it's getting better. And so if you're trying to recruit from an undocumented worker population, you probably shouldn't be on EVerify. It's going to scare off and nix out. Should nix out a lot of your applicants unless they have really, really good fake identifications. I recommend an I-9 immigration audit every year, 2 years at the most. We'll talk about the image program in a second. And then anyway, here's some to-do lists for creating a to-do list, and an I-9 audit checklist is always recommended, and then doing training. If ICE shows up, what should you do? So here's some bullet points that should be part of an immigration protocol response that you put together. So first things first. Well, first thing is you should contact your lawyer, right? So get me or somebody else on speed dial to deal with ICE. That's what you're going to want to do. But don't allow them to, unless they've got a warrant, don't allow immigration or the Department of Labor to come in and look at your I-9s. They technically can give you 3 days, and a lot probably needs to be done to clean them up in those 3 days. Don't allow the removal of original documents. Give them copies. Help them make copies for them, for these government agents if they're there. Get their business cards. Call your attorney. Obtain a copy of the warrant. And then have somebody, if a lot's going on, have somebody document, memo everything that's going on. Who said what, when, where, what's going on, timeline. There could be resulting litigation from a lot of this. There could be a lot that goes on, and a lot, especially if it's a major raid, a lot's going to be going on. Document all of it, because there could be litigation. There could be administrative agency stuff as well that goes on after that. We want to have, and your lawyers are going to want to have a good record of how the whole thing transacted. And then prepare a media response, because a lot of times ICE, they tip off the media, the local media, sometimes national media, that they're going to be doing a raid. So you want to be prepared for that. Like I said earlier, this isn't an I-9 webinar, but just general basics of the I-9, because I do want to talk about auditing and some tips on the I-9. So if you're not using the current form, you need to be using the current form. So for all new employees or rehires that you're doing Section 3 for, you needed to switch over to the new I-9 form about a month ago. So maybe exactly a month ago, yesterday. So September 18th, 2017. And so if you take a look at the bottom of the I-9 form, it's the one that says that it's dated July 7/17, 2017. So that's the correct form if you're taking a look at the current I-9s that you're using. But Section 1 is for employees to fill out. It's just basically employee background information. The key is Section 2. That's the second page of the I-9. And Section 2 is where it's the guts. It's where you meet your obligation of hiring people with work authority. And so, you want to complete fully Section 2 and record the documents, and not over-record the documents. If they show you just a List A document, only record the List A document. Don't ask them for a B and a C document at all. And then Section 3 is where the employee has new work authority. Now, if you go, I've watched these. They're really exciting. I tried to get one so I just couldn't do it really well with GoToMeeting or GoToWebinar here, but immigration just re-released their I-9 vignettes. So they've got, if you go to the USCIS.gov, I-9 Central website, there's an I-9 Central website, if you believe that, and they actually have the videos that USCIS has put together, and they're between 3 and 5 minutes long, and they're comical, as most of those like workplace videos are. Even though they're new, it's like they're dated already. So whatever. You can check them out. They're worth 10 minutes of your time if you're doing the I-9 or having a colleague who does the I-9 and you want to do some training. It's just a general overview type stuff. But again, like most workplace produced videos, they're corny and comical if you enjoy corny training videos. What you don't need to do is sometimes it's just as important as what you do need to do. So what you don't need to do is, going back to my Destro or Larry Lebowski situation, he just fessed up that he's illegal. He's an illegal lumberjack from Canada. He just fessed up to that. Do you have to notify anybody? Do you have to notify the government? Absolutely not. You don't have to be the police on this. You don't have to notify the government. So could you? Yeah, go ahead. You could contact the police. I don't know if they do anything. You could tell them that there's an illegal, lumberjack from Canada here, but you don't have to. And I generally advise not contacting the police on employees. So it can be seen as retaliatory, especially if they're in a union or they're threatening, you with like discrimination or work comp claims or something like that. Contacting the police to deport them, and employers have done that. There have been lawsuits where that's come about, and so just generally, I don't recommend contacting government authorities about potentially illegal or known to be illegal workers. You should act on speculation. You don't have to act, I'm sorry, you don't have to act on speculation, but what you do need to act on is if you have a substantial and a number of circumstantial evidence. But if you just have suspicion, because the person's from Mexico, or the person has a different last name, or they speak with an accent, or whatever it is, that's just mild suspicion that doesn't bring you up to the level of understanding that the person's undocumented. So I wouldn't, you don't have to act on that. You have to act on knowledge, and knowledge could either be direct, like the person, like Larry Lebowski, saying that he's illegal, or it could be the knowledge could be based on circumstances, which could be some suspicious documents and or somebody calling, something from the government, that whole laundry list of things that we went through. You don't have to be an expert on counterfeit documents. Fine if you are. I generally don't recommend it, but just have to be a reasonable person. But make sure you look at the document. If the document's obviously a fake, don't take it for the I-9. Ask for something else. If the document looks pretty good you've done your due diligence, you've looked through it, it looks pretty good, just take the document. That's good enough. You don't have to contact other employers about illegal workers. You might get a call from a future employer saying, or an employer, in a small town that that's about to hire somebody. You don't need to contact that employer to tell them. And again, I'd probably not do it because you don't know if things have changed. And it could be a tortious interference with prospective economic advantage, and that's a lawsuit, right? That's a claim that you could be sued for. So I guess I wouldn't go above and beyond in that. And then you don't have to examine more documents than are required. In fact, that's a potential form of document abuse. Tips on the I-9. Here are a bunch of my tips. Section 1, pretty obvious. Again, you can look at my I-9. For those of you on the hotline program, you can watch the I-9 webinars. And then Section 2, don't take expired documents. That's kind of my big tip, since they changed that rule a few years ago. Section 3, there are my tips on that. And then I want to show you. We've got 5 minutes. So this is what I said, kind of similar, but I want to show you some audit tips. So if you are going to audit your I-9s internally, so you might externally, might send it out, outsource it, but if you're going to do it internally, here are just a handful of tips for you, right? So if you're looking at the I-9s, you're doing your annual audit or biannual audit, don't make changes to Section 1. If you find that there's a mistake in Section 1, bring the employee back in and have the employee make the changes. Ask the employee to make the changes. You, as an employer, are never supposed to touch Section 1 of the I-9. So first page of the I-9, Section 1, don't touch it. Section 2 if there's an error, and there are going to be errors unless you're like the most perfect employer with the I-9s ever, and odds are you're probably not, but if there are errors, here's what you do. Draw a line through the incorrect information. Enter the correct information, or if it's been omitted, fill in the blank, and then initial and date the correction, or where you filled in the previously omitted information. And that's it. I recommend also using a different color ink pen. So, green or purple or something like that. Red, I guess, as well. So that's another tip I would throw in there. But that's how you make changes to Section 2. If there is no I-9, again, like I said before, you have to have an I-9 for everybody. But if there is no I-9, do a new one. Don't backdate it. If you find a partially completed I-9, staple it to the new one and use the new form. You don't have to go back and get the old form from the time that the person was hired. Use the new form, finish off the I-9, and then just staple the two, and it'll at least show good faith that you were trying to do the best you could. If the photocopies, if you're doing the audit and you've got a photocopy practice, you don't have to photocopy documents, but if you do, and you're doing it uniform for everybody, that's fine. And if you look at the photocopies and they don't look legitimate, call the employee in and ask the employee to provide that's when you get into the suspicion, right? Ask the employee to provide feedback and to address the situation. And if you're not satisfied because the documents, they still to you look pretty bad, if you're not satisfied, ask the employee to provide sufficient documents to satisfy Section 2 of the I-9. List A document or a B and a C combo. You don't ask for specific documents. Like if they have a bad looking Social Security card, don't ask to see another Social Security card. Ask to just get the minimums for the Section 2 of the I-9. If you use the wrong version of the I-9, good news, you're not going to go to jail. So, again, no promises, but, I am an attorney. I can't make any promises. But if you use the wrong version, I think you're probably going to be okay. Just, try to show in a memo that you recognize it and that you switched once you realized you were using the wrong I-9. This comes up a lot. If you're suspicious and you're going through these suspicions and you're going through an audit and you think, oh, this employee, I'm pretty suspicious of them, don't do EVerify for them. EVerify is only for new employees. The only situation where that's different is if you're like a federal contractor and you're taking on a new contract, then you can do EVerify for current employees. Otherwise, as a member of EVerify, you only do EVerify for new employees. Unless you forgot to do EVerify, then you can kind of go and fix your mistake. But that's kind of the only circumstance where you can. Can you ask for specific documents to satisfy Section 2? I already mentioned that before. The answer is definitely no. Okay, so if you're an employer, and we've got like 2 minutes left, if you're an employer and you want to do more than just like your typical I-9 and training and all that, what can you do? You can register for EVerify, or you can register for Image. Now, most people know what EVerify is. It's voluntary unless you're, a federal contractor, or in a couple states that do require EVerify. There's a new poster, by the way. I'll go and put up a new poster if you're EVerify members if you haven't already. But the bigger one that a lot of employers, not a lot of employers are on the program, it's Image, and that's where basically you're inviting the government to come in and to you're enrolling in EVerify as part of that, but you're allowing the government to come in and audit you, and I don't generally recommend that. But if you really, really want to be up and tell the media that you've done everything possible, it's great defense for a lot of things. Invite the government to come in and be a partner with them and have them do your inspection and clean up and review your processes and all that, and the government will do it, and you can enroll in the Image program, and some employers have, and they continue to enroll, but you're opening up the doors to the government to come in at that point, and that could be good and that could be bad. So I would go in eyes wide open on that one, but it's definitely something that you could do. Here's the most recent, as of a few weeks ago, the most recent statistics on EVerify. Interesting that almost 99% of all workers out of the 25 million workers that were processed through EVerify, 99% of them were confirmed for work authority. So it's like that 1%. You can see how it breaks down with that 1%. And so it's a very, very tiny number of workers that are coming up as mismatched and everything. So, and that's it. 1 o'clock. Thanks for your participation today. I really appreciate it. If you have any questions, you're welcome to follow up with me at kmosher@thompsonco.com, or you can give me a call at 651-389-5007. I appreciate everybody's attendance, and feel free to follow up with me or any attorney at Thompson Co. with any questions that you might have. And next month, we'll be back in a month with our next HR Best Practices webinar. Thanks.